settled it because we needed to get it done. And that's what
I don't get your point. What are you saying?
we had a lawsuit against the county earlier this year in which a settlement agreement was reached for the same amount of money, $125,000. We never, and I'm not saying we shouldn't, I'm just saying that we didn't have the same discussions over that settlement.
It's mitigated.
We had a resolution, it was mitigated, we cut it off, we cut the dragon's head, we ended our, that was it. That's all I'm saying is, I don't think it's a bad approach.
Well, I believe that the settlement you're talking about with the health trust, is that correct?
Right.
That affected everybody in the county. I think where the apportionment of the settlement funds that at least I have the feeling, and I think it's felt by some other legislators that, you know, the sanitary sewer district, and since you're an enterprise fund, you are sustained by user fees, and it doesn't have an impact on other county taxpayers. So that would be the difference I would see there. But the real reason I asked for the floor was I would like to make an amendment to remove the entirety of the resolution language of the body and replace it with the resolution approving settlement body language that was forwarded out by the clerk of the legislature this afternoon, with the whereas clauses indicating that the legislature has reviewed the stipulation and approves it to content and form.
I'll second that.
Discussion.
We have some discussion, going back to the original discussions on this.
Okay. Hearing none, all those in favor of the...
Aye.
Aye.
Opposed? Abstained?
During, since the second corrected deed was filed in 1989, from that point on, was there ever any title insurance that was offered or taken on the transfer of these properties, either from Mrs. Cruz or the current reputed owner?
When the sanitary district bought the property in 1972, they got no title insurance. When Mrs. Cruz's husband actually got the deed originally, and she got it by his death as an executor. So the 1989 deed went to her husband, there was no title insurance. When the transfer went from Cruz to Patterson, Cruz and Patterson shared an attorney. That attorney had an abstract of title. And that attorney apprised both Cruz and Patterson that there were title issues, to use his language, with regard to the property that Patterson was trying to buy, and also indicated that the tax map showed that the bounds of the property that they were buying included lands that were owned by the county. Nevertheless, Patterson bought the property, knowing that these title defects and these claims that the county owned it were evident. But there was no title insurance issue to those Mr. and Mrs. Patterson. There's no title insurance, to my knowledge, ever acquired by Richard Cruz when he bought it in 1984 and then finally got it in 1989. And there is absolutely no title insurance that would benefit the county or the sewer district.
So when the attorney in Canachahari put this together and had a closing,
Between Cruz and Patterson.
right?
Yes.
They were made aware that there was a clouded title.
The attorney in Canachahari specifically put in his notes that there were title issues, to use his words, and that there was a discrepancy with regard to the location of the property on the tax maps, and that the tax map showed that the land, or at least a portion of it, was that he was supposedly buying, Patterson was supposedly buying, was actually owned by the district. That's right.
The next question is, by virtue of taxes being paid on the property, by virtue of the county accepting the taxes for the same, does that indicate any ownership or does that create a question whether at some point in time the county accepted funds on this to pay taxes on this property?
Right.
You know,
I
is
understand
that
the
a question of judgment?
No. The case law is clear, and it's for a long, long time. A person who a deed that is a void deed. Void means it's a nullity. It means it never happened. So if a county or a town or the city of New York, there's a famous case, city of New York, purports, or director of real property purports to convey this large tract of land to an owner. The owner then cleans it up and builds on it. 20 years later, court rules, the city still owns the property. Title never transferred. But what? The guy who bought it, because he had paid taxes on it, and because he had improvement, had a right to make a claim for the value of the improvements that he made. This is exactly our case. So the answer to your question is, just because you paid taxes on it for 20 years, and the county accepted those taxes, and just because the county tax map people drew a map and said this is your property, means nothing. Absolutely nothing in terms of who has title. And that is absolutely clear.
Patterson is releasing us from that.
Releasing us from what?
Patterson is
That's
releasing
one
us.
thing.
That's one thing in the settlement is that she's never gonna come back and say, I did all this work, you owe me now. That's part of this.
Right.
So when I first started looking into this, I thought about adverse possession. I was looking at the county's side.
Yeah.
But is there an argument from Patterson's side or from Crew's side that through adverse possession, since no one stopped them from attaining use of the property or stopped them from performing duties on the property, is there a case there for adverse possession?
The answer is absolutely no, and here's why. A private party cannot adversely possess or gain a prescriptive right to continue to use property that is being held by a municipality for a governmental purpose. So it's absolutely, and it's not even part of their claim. Their claim is only, we are entitled to rent because we own it, so say, okay? On the flip side, if you want to see the pleadings of our case, we argue we have title by deed, we have title by adverse possession because our plan has been there since 1974. We have prescriptive easements for access and for our sewer lines. No, there is no way, even if we were to lose on some of the beginning issues about who has title by deed, the county would still have title by adverse possession and prescriptive rights to maintain the facilities there. We would never have to pay to keep our facilities there.
So I understand, and I want to completely understand. So what you're saying is a single entity, not a municipal government, cannot charge for adverse possession against a governmental.
That's right. A private party cannot make a claim against a governmentally owned piece of property, provided that land is being used for a governmental purpose.
Okay. My next question is, when was the work completed by the people that are asking or saying that they had the right to mechanics?
The mechanics liens, like I said, were filed in December and January.
Of this year.
December of 2014 and January 5th of 2015.
So my question is, when was there,
Right.
I'm trying to establish what you were saying.
And I'm gonna get to that. And I went to the county clerk's office, and I got a copy of those two liens. Because in the lien, when you file a lien, you have to say, when was the first day you did work? When was the last day that you did work? The last day that Mead Contracting claims to have done work was an unspecified date in 2010, which is less than 6 years from now, just so you know. And Mr. Lance Conley of Atomic Trucking claims that the last work that he did was in April, I believe it is, 2006, which is more than 6 years. 6 years is a statute of limitations.
Do you have anything further, Bob?
I'll be quick.
Okay.
I want to review and make sure that I don't. Can you explain to me, in this settlement, the stipulation
Berthold is her fiance. He claims that he acted always as her agent. And as her agent, personally did work on this property to improve it. And also as her agent, he engaged other contractors to do work. And so his claim, if you read why he's in the lawsuit, it says that he claims, and he gives a release with regard to work. Let me just see if I can find it. I believe it's in the release. Release is exhibit B. Let me just, if you give me a second, I can find exactly the language that we used in the agreement. It basically says that he is giving up any claims that he may have personally for work that was done that improved the property. And any claims that he has a right to receive any benefit from the property. That's what he's in there for.
So he's not included in the chain of title in any way.
He's not in the chain of title. The way this chain of title worked out actually was that the contract between Mrs. Cruz when she went to sell it was with Mr. Berthold. And then they allege that just prior to the closing, Mr. Berthold verbally assigned his contract to Ms. Patterson, who then executed the contract in deed and got the deed in her name. He has been an integral player, I can tell you, working as the agent for Ms. Patterson. Okay, and he does claim over $100,000 worth of work that he personally did on that site. He has no proof, no records. He claims he lived there for 6 months and did work every day of every minute.
I would like to further make an amendment to reflect with the altered language that the entire settlement fee be passed along to the sanitary sewer district for full payment by that district and no payment of the settlement by the county of Montgomery.
I'll second that.
Discussion.
What do I want to say? This agreement, and correct me if I'm wrong, Doug, but wouldn't we do that when we transfer the funds, which we have the ability to pay? It wouldn't necessarily be in the agreement. It has nothing to do with the agreement. What we want to put,
the stipulation, no,
right.
but you can make it part of your resolution, that that's the mindset of the county legislature at the time that it agrees to the settlement, an expectation that it will agree to the settlement. Or you could do it at a later time. I would say that you would have the ability to make your approval of the stipulation and settlement contingent upon that.
I guess hypothetically, I'll throw this out there. Sewer district has no money, whatever, with the date of settlement, has no money. It's still the county's responsibility. There's no way around that.
Well, I would suspect that in the interest of time, if the sanitary district, if in fact this proposal, which legislator White's just put forth as an amendment, were to be adopted, as a practical matter, in order to effectuate the settlement and make the payment, the county might find itself, depending upon the finances of the sanitary district, in a position of having to, for lack of a better word, front the money and recoup it at a later date or dates from the sanitary district, some or all of the money.
From its fund balance, whenever.
If the sanitary district, I heard what you said earlier about some money to the sanitary district from FEMA. I don't know the particulars of the timing of that and so forth. In the event that the district was simply unable to write a check for $250,000
That's
at a particular point in time, relatively
If we
soon.
had to write the check today,
Mhm.
you couldn't do it. If you waited a week, you might be able to do it.
It was my understanding, yes.
I just don't want it to be contingent upon the settlement itself.
I just have one more question. Just, can you explain for me really what the stipulation and settlement agreement, how does that come about? Does somebody from our side suggest to you that it's time to settle?
Here's how it came about. We have had many efforts to settle over the years. When, in 2012, there was no agreement, we decided then, at that point, the sanitary district and the members of this legislature on the board decided we should make that motion for summary judgment and get a final decision on who owns it. After we got that decision in July, and as we were getting ready to file our appeal in August, we filed our appeal. We have to notify the other side that we filed the appeal. As soon as they found out that we filed the appeal, they said, would you like to talk about settlement rather than have the expense of an appeal? And we started in September and October and November working on settlement, negotiating. We had meetings at the sanitary district, what would be a fair and reasonable settlement that we could work on. We sent that to them in November. In November, I guess it was the early part of December, we got back an answer saying, that's not an acceptable proposal, here's what we would accept. And then in December, the sanitary district board and the members of this board who are on that district said, okay, here are the terms that we are willing to settle for. And I was directed to prepare the settlement agreement. And the settlement stipulation and settlement agreement is a document I prepared with almost no changes after the final discussions in December from the other side.
At that time, did you give the board and the district, did you give them an indication like you did for us with respect to being on the 1 yard line, anything like that?
Twice. Once in November and once in December. Perhaps even once on January. We think in January 10th I did it as well.
Thank you.
Can I? To Ken's credit, he's been telling us we're on the 1 yard line, and there's just a philosophy on a majority that just want to get this done. So, you know, I would never say that he hasn't told us that. He's told us that for, you know, we've just had, me personally.
Well, my question just goes to whether or not you take advice of counsel.
Any other discussion? Hearing none.
Quick question. What's your estimate of legal fees going forward to finish this litigation?
I think I told the sanitary district board that I thought that we could close out this litigation for around $100,000 worth of legal fees, and that we would anticipate having to pay out some number of dollars perhaps for the improvements that could be proven at trial. I think that a litigating this out and expecting that we might have to pay something for the improvements that were made to the property, that it would be less, you would be a $100,000 savings to do that versus pay the settlement today.
I don't have any more questions, but, you know, this is a $250,000 decision, and my brain is saturated, I'll be honest with you right now. I tend to want to support doing this and putting an end to it, but I really would like some time to look at all the numbers that we're talking about so I can make a good decision, not
Yes.
Legislator Isabel.
Yes.
Legislator Patel.
Yes.
Chairman Kelly.
Yes.
Legislator Quackenbush.
Yes.
Legislator Diamond.
Yes.
Legislator Whites.
Yes.
Legislator Beniak.
Yes.
Legislator Duchessis.
Yes.
Yes.
Thank you very much for your time, Mr. Ayers.
Let me just see if I understand. So the resolution to accept the settlement and go forward with the settlement is approved, is that right? And the funds are gonna come from the sanitary district, is that, I don't really care where they come from, I just need to know that it's done, right?
That's the only
Okay.
change in the
Correct.
resolution.
Right, okay.
That
That's just-
change in the
As
resolution.
long as I understand what we're doing, I would like, since this resolution requires it be given to this county executive for signature, the resolution specifically says it's to be
Oh,
given.
the stipulation.
Stipulation.
The stipulation is going to be signed.
Right.
The resolution says that the stipulation will be signed.
Right.
So I'd like to see a final version of this with all the votes and everything, so that I can then present it to the county executive for signature. Thank you.
Thank you for your time.
Before we go with this,